So GOA is now seeking Supreme Court review in their case challenging the ATF's bump stock ban. So let's talk about this. But real quick, before we jump into this video, if you think the ATF should be abolished, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has some amazing coffee out on the market, and they are also huge Second Amendment supporters. They give quite a bit of their proceeds for sales like on GOA's branded coffee, FPC's branded coffee. So they donate to Second Amendment organizations, plus they have amazing coffee. So if you guys are interested, you can use the link down in the details section in the comment section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, a case challenging the ATF's interpretation of bump stocks as actual machine guns is now seeking Supreme Court review. The case we're going to be talking about is called GOA v. Garland. Now, some quick background on this case, on this issue, and why this is so important, not just for bump stocks, but other types of ATF actions which violate our Second Amendment rights. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of $250,000 if they failed to either destroy or to surrender the devices. Now the case here is a challenge to the ATF's final rule on bump stocks, and it is led by GOA. This case was determined in favor of the ATF at the district court level, and eventually this made its way up to the Sixth Circuit en banc panel. After hearing oral argument, the Sixth Circuit's en banc panel issued their order, but it was a rare deadlocked 8-8 decision. So the order of that en banc panel was as follows. Following argument heard by the court en banc on October 20th of 2021 and a conference among the judges, the court divided evenly, the 8 judges voting to affirm the judgment of the district court and 8 judges voting to reverse. Consequently, the judgment of the district court is affirmed. So essentially, since the Sixth Circuit en banc panel was deadlocked, the tie went essentially to the runner. This split between the judges came down to the pro-ATF side saying Chevron deference supports their interpretation of bump stocks as machine guns since the term was ambiguous. In contrast, the other side of judges said that the term was not ambiguous and bump stocks were never intended to be included in the term machine gun. This side also argued that courts have improperly used Chevron in the past and also incorrectly excluded the use of the rule of lenity. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference given to an administrative action. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency. The interpretation of the definition machine gun does involve criminal penalties, and therefore the argument would be that the rule of lenity would direct any court to interpret any ambiguous term in a way that is most favorable to the people, not the ATF. Now, in response to that Sixth Circuit deadlocked opinion, GOA has now filed for Supreme Court review. In their petition for writ of certiorari, they present 3 questions for the Supreme Court. First, whether the definition of machine gun found in 26 U.S.C. section 5845 subsection B is clear and unambiguous, and whether bump stocks meet that definition. Second, whether Chevron deference should be given to agency interpretations of ambiguous criminal statutes displacing the rule of lenity. And third, whether courts should give deference to agencies when the government expressly waives Chevron. In their first argument section, GOA states that lower courts finding ambiguity in the language is what led to the conflicting decisions. GOA claims at its core, this case presents a pure question of statutory interpretation, and one that 8 judges below concluded is not particularly difficult to answer. The question is whether common firearms accessories called bump stocks constitute machine guns under the statutory definition. They go on to say the answer to that question is a definitive no. A firearm equipped with a bump stock does not meet either prong of Congress's carefully crafted an unambiguous definition of machine gun. Such a firearm does not fire automatically by a single function of the trigger, but instead fires only one round each time its trigger is mechanically functioned. Likewise, in no sense does it function automatically, but rather requires complex human input far in excess of single function of the trigger. GOA argues that instead of finding that the term machine gun is unambiguous and clearly does not include things like bump stocks into that definition, courts have instead muddied the waters by trying to insert ambiguity in the phrases like single function of the trigger. By inserting ambiguity into clear terms, courts have opened the door for the ATF to have deference when no deference should ever be given. In their second argument on why the Supreme Court should hear this case, GOA argues that courts are split on when to use Chevron and when to use the rule of lenity to resolve ambiguities in criminal statutes. They say despite the parties' agreement that the statute is unambiguous and that Chevron has no role to play in deciding this case, the district court, however, decided to go their own way and decided to find that it was ambiguous and that court was obligated to grant Chevron deference to the ATF's allegedly reasonable interpretation. They go on to elaborate that in so doing, the district court entirely failed to address the elephant in the room, the fact that the final rule creates a new federal felony by including bump stocks under the machine gun ban. However, like I mentioned earlier, and like GOA references, the rule of lenity should be used by the courts to decide what actually should be going on if they decide to go down this path. This interpretation of the definition, if it was ambiguous, does implicate felony charges. It has criminal implications. And since this has criminal statutory implications, the use of Chevron would be improper. GOA argues that the Supreme Court needs to resolve this issue on when lower courts need to use Chevron and when they must apply the rule of lenity. Finally, GOA argues that the court must hear this case to once again clear up the issue of whether Chevron can be waived by any agency. In this section, they point out that the final rule repeatedly stressed that the ATF was neither exercising policymaking authority nor claiming deference. Rather, the ATF denied the existence of a statutory ambiguity and claimed that the ATF believes these definitions represent the best interpretation of the statute and believes its interpretations accord with the plain meaning of the statutory terms, i.e. they said that the definition is very clear and they're saying there is no ambiguity in the language. So that's important. The ATF is saying that this term machine gun is clear and therefore not ambiguous. Because of this, they are not invoking Chevron deference. Instead, they are waiving it. The argument that the ATF waived Chevron was presented to the district court, which acknowledged that fact that the Chevron was waived by the agency, but still decided to apply Chevron in their favor anyways. GOA therefore points to various cases and even Supreme Court language indicating that when an agency waives Chevron deference, they cannot be granted it by a court. Therefore, in this section, GOA argues that the Supreme Court needs to review this case and review is necessary to resolve this issue of waiving Chevron deference. So that's a quick rundown of the cert petition filed by GOA in their bump stock ban case. Also, I want to note to you guys real quick that there is a different bump stock case that is currently looking for Supreme Court review as well, and that's the Poised case we've talked about in the channel in the past. That case deals with similar issues, it's just out of a different circuit court. Poised has been scheduled and removed from Supreme Court conference multiple times, so I will definitely be keeping my eyes on this case as well as the Poised case because, again, this has huge implications not just for bump stocks, but also has to do with the ATF's overreach, redefinition of various terms like they have with frames and receivers, pistol braces, bump stocks, triggers, solvent traps, all these things that the ATF engages in when they do redefinitions, new rules. All of those things could be implicated by these cases if the Supreme Court decides to hear this issue. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits that notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars. This nation will be maintained by armed scholars.